Hey, good afternoon. Thank you very much. I did a shower today, so guess maybe this is another one of those things of speaking separate languages. Okay, so today we're going to try and wrap up. We're going to try and wrap up our discussion of co-tenancy because we do have other things we need to cover. So today we're going to talk about how co-tenancy plays out in a world of equity. Okay, so let's start by reviewing an idea, right? Let's say that we have a piece of property and it's held by A, B, and C as joint tenants. Okay. So let's say that these three folks sell the piece of property. How does the money get divided if they hold it as joint tenants? That's what joint tenants mean, right? Is that it's all you're all equal. There's no question about you guys about having different sized shares. So, right, Keandra's absolutely right. If these three are holding in joint tenancy and they sell the piece of property, then they each get 1/3 of the money. Now let's say that we have these three, they go in together, they buy the piece of property, and then A dies. Now, if they sell the piece of property, what are the shares?
Half and half.
Ben's exactly right. So B and C each get half. Okay? Because that's how joint tenancy works, right? Joint tenancy with right of survivorship. By the way, I figured out why in the United States we talk about it specifically that way. It's that the United States follows the rule that Antigua and Dominica do of presuming a tenancy in common. So everywhere else in the Caribbean and everywhere else in the Commonwealth, if you have a joint tenant, if you have a co-tenancy and there's no limitations on it, you presume a joint tenancy. In Antigua, Dominica, and the United States, you presume a tenancy in common, which is why in the US we talk about joint tenancy with right of survivorship, because you have to have that language to create the joint tenancy. But Adrian, to go back to what we were talking about before I got distracted, Adrian's absolutely right. You wipe out one of the joint tenants, their share gets eaten by their co-tenants. And so B and C now own half of the property. So now B dies. Who owns the property? C. C owns the whole thing, right? But A's got heirs, right? And so does B. Is this fair to them? Right? Their ancestor participated in the purchase of this property and they're just wiped out. Does that seem fair? Chandra says no, but she's not sure. You guys, I mean, does it seem fair to you guys, right? You have somewhat developed moral senses.
Sir, I think is the fact that that's what they sign on to. That's what they agree to. Because when they execute the document or when they executed the conveyance, well, I think they should have been advised by the attorney whether it be a joint tenants or tenancy common. So they're bound by their signature. So that's what they're signed up to for. So that's what they get.
Okay, right. I think that's an argument that you can make. Bonnie disagrees. Keandra disagrees. Why do you guys disagree?
Well, I disagree because you asked if it seemed fair, and I said no, period. It doesn't seem fair because if they have heirs, it would be the natural thing for the heirs to earn that piece of property, but it's not so.
Maybe, right? I mean, the real sort of, to the extent that there's any injustice here, right? The injustice would be in the event of, someone dying tragically and unexpectedly, right? Because I think Adrian's right that, to some extent, this is what you sign on to when you participate in a joint tenancy, right? You sign on to the possibility that you lose your share, your heirs lose your share, and whatever investment you made is just wiped out, okay, and gets eaten by your co-tenants. But you don't have any control over when you're going to die, right? You and your co-tenants may have made plans over the next, 5 or 10 years to phase out of the joint tenancy, right? They're gonna buy you out over the course of several years, but then you drop dead and your heirs don't have any ability to make a claim. You're just done, right? So that's a windfall to your co-tenants that maybe isn't fair. Mike asks, what was the intention of the conveyance? And the answer is, we don't care. There's a joint tenancy. Here endeth the conversation at law. Okay? But equity says, this is some bullshit, if you'll pardon my French. Equity says, this ain't okay. And so equity says, we would rather have a tenancy in common. Okay? So there's a saying that keeps cropping up in the readings from one of the cases. The only equality in a joint tenancy is the equality of chance. And what that means is that with A, B, and C, right, they don't know which one of them is going to drop dead first. And so they all have an equal chance of being the last man standing. But that still doesn't seem fair. Okay? So, sorry, I'm checking my notes to see what I wanted to talk about next. Okay. So there can be situations where the joint tenancy is held at law, but the equitable interest is a tenancy in common, right? So you guys remember a couple of weeks ago, we talked about how trusts involve the separation of legal ownership and beneficial ownership, okay? So legal and beneficial, right? And so these are the kinds of situations that are sort of made for trust, where you have A, B, and C holding as joint tenants. And on the beneficial side, you have A, B, and C holding as tenants in common. And so when that is the circumstance, when that's what happens, let's go through this problem again, right? So we have A, B, and C. Okay. So same sequence of events as before. A drops dead. So what happens on the legal side? Exactly. A loses their legal interest. What happens on the beneficial side? Right. A gets replaced by D, right? And D takes the whole share. So it's still 1/3, 1/3, and 1/3. Okay. But B and C hold the legal title as joint tenants, but they hold it for the benefit of themselves and D as tenants in common. Okay. So now let's go to the next step, right? We kill B. Well, okay. I don't kill B. I can't speak for the rest of you. But somebody kills B. What happens on the legal side? B's interest is wiped out, right? So now C is the sole owner of the property with whatever estate there was, right? It could be a fee simple and absolute, it can be a life estate, it can be a fee simple determinable, whatever. But C's now the. What happens on the beneficial side? Right, there's two of them. So they take B's share split between them. So now C and D own 1/3 and E and F each own 1/6. But it's only the beneficial interest, right? The legal interest is held solely by C.
So, sir,
Okay, so one second, there's a couple of questions in the chat. So Keandra, I just want to point out, right, that E and F split B's interest, but B's beneficial interest didn't grow. You're absolutely right that B owns half of the legal title, but they don't own half the beneficial interest. And E and F only take the beneficial interest. Okay. And the other question from the chat from somebody who needs to check their display name is D, E, and F are the heirs here, right? So A is D's sole heir and E and F are B's joint heirs. Okay. Did I get him? I don't think I did. All right, now I'm sorry, there was a question in the room.
so if C it says the property.
C can only sell legal title. They can sell their beneficial interest, but they can't sell the other beneficial interests themselves. So they can sell it, but the proceeds have to go to these.
Okay, so I think I missed something there. How does this arise? As in out of equity bonds?
What do you mean out of equity? Like, ask your question again. I'm not sure I understood it.
How does that happen? The distinction between the legal and beneficial interest? Because traditionally, there is intermediate as a different beneficial interest, right?
So how can this happen? Like, let's say that there's family property, right? And it's given to all of the children of the, the ancestor, whoever they are, jointly. Okay. And then they start dying. The children start dying. Legally, the joint tenancy collapses, right? But the heirs to the dying children have an equitable claim.
Okay, so the principle is that they may have a claim. That's the basis.
I mean, in law, everything is a maybe until you have a court order saying it's a thing.
Okay, so what is this? What? I know you don't like when we ask questions in an exam format, but it's sad to say that's what's happening. So if you get a question and the question says, this is a joint tenancy with 3 persons, A dies, and then basically the question is asking, do their heirs get it, or does it just pass to the next? What are we expected to discuss from?
Yeah, so this would be an opportunity for you to discuss the creation of a trust, right? The creation of the separation of legal and beneficial interests, the statutory trust under the Law of Property Act of 1925, which, by the way, only applies in Belize in the Caribbean. Everywhere else in the Caribbean, we use pre-1925 co-tenancy rules. But the only difference, so sorry, I should have said this. Someone messaged me and asked what the question was. The question was, if you get an exam question that sort of looks like this, what are you being asked to discuss? Okay. And the answer is, I mean, the truest, most honest answer is it depends on the call of the question. Okay. If the call of the question says, list the interests created by this fact pattern, all you have to do is tell me that you have a joint tenancy and the possibility of a beneficial tenancy in common. Okay. We're going to talk about the situations in which we presume that an equitable tenancy in common has come into existence. So there are a few situations where we assume that this divide has happened. Otherwise, unless there's some evidence of a division, you should not assume it. So here's a couple of things that I think will sort of maybe clarify this a little bit. The first is, if we're dealing with Belize, if the fact pattern mentions that you are dealing with property in Belize, you need to deal with it using the LPA rules, which means that there's no such thing as a legal tenancy in common. So if you think there's a tenancy in common, you may be right. If there is, it is only a beneficial tenancy in common, and the legal title is held as a joint tenancy. Okay, so that's the first case, is anything that happens in Belize involves this division because Belize does not allow the legal tenancy in common. Okay? Everywhere else in the Caribbean, it's allowed. The second case is an unequal purchase money. What does this mean? What does this mean? Let's go back to our old friends A, B, and C. Let's say that they've bought a piece of property and it cost them $1 million. Just because it's a nice round number, no significance to the number, okay? And A puts up 300,000, B puts up 500,000, and C puts up 200,000. Okay. Now, if they bought the property in Belize, then we can say that A owns 30%, B owns 50%, and C owns 20%, right? To match their contributions. If they buy anywhere else in the Caribbean, they have to take, no, I'm sorry, that's backwards. If they buy anywhere else in the Caribbean, we can divide up their ownership this way. If they buy in Belize, then we have to call them joint tenants. And they all own 1/3 shares because joint tenancies cannot be fractionated. They have to be equal shares.
In Belize?
In everywhere. Everywhere that you have everywhere in the Caribbean that you have the common law, so all of the Anglophone Caribbean, joint tenancies are equal shares.
Okay.
So joint tenancies are always equal shares.
So the exception is in Belize.
The exception is in Belize where you can have a tenancy in common at law. No, I'm sorry. I keep getting that backwards. So Belize, no tenancy in common at law. Let me circle that. Yes.
So could you, okay, so I'm gonna pretend like I haven't said anything. The last thing I saw was 300K, 500K, 200K.
Okay, right. So in Belize, these guys have to take as joint tenants. Everywhere else in the Caribbean, if the conveyance does not contain words of separation, except in Antigua and Dominica, they take as joint tenants. Okay, so there has to be, so everywhere except for Antigua and Dominica, if you don't see any special words, this is a joint tenancy, even though they've brought different amounts of money to the table. Equity says that's not fair. Keandra says, regardless of how much they pay, that is correct. That's exactly what we're saying is regardless of what they pay, if the conveyance does not state a separation, this is a joint tenancy. And in Belize, it's a joint tenancy no matter what, okay? Equity says this isn't fair. And so equity says, okay, A, B, and C can be joint tenants at law. That's fine. We're not going to disturb the law. But in equity, they hold as tenants in common for the benefit of one another right? So the beneficial interest belongs to the legal owners, but in shares that are equal to their contribution. Okay? This is becoming a lot more complicated than it really needs to be. Let me try and distill it for you guys, okay? Law does not care what you bring to the table. Law says everybody owns equal shares. Equity says nonsense. Your shares are determined by your contribution to the purchase. But equity can only affect the beneficial interest. Okay, so the folks in the chat asking for repeat, does this help? Okay. Is this statement by equity throughout the islands? So you're asking, does equity say the same thing throughout the islands? The answer is yes, with some twist, with a twist. Okay. Okay. So here I think maybe something that helps. Let me see if this helps. Is that, where'd my eraser go? It's right here. We have law, we have equity. Law is concerned with the form of things, right? Law wants to know, did you jump through all the hoops? Did you do everything that you're supposed to do? And if you did, then this is what you get. And there is no change based on what's right or what's fair or what the facts are. The only question is, did you do what you needed to do? And what do you get when you do? Okay, so law is formalist and rigid and limited. So when we say that at law, you can only take as joint tenants, this is why. Because law does not consider the fact that there may have been different contributions. Right? Is circumstantial and flexible. And as I was told once when I was flabbergasted at a chancellor's ruling that didn't make any sense, unlimited. Because what I was told was that a chancellor sitting in equity can do whatever he wants. So equity says, now wait a second, if you brought different amounts of money to the table, you deserve to be able to take based on what you brought to the table. 1 second, okay? And so equity says you receive shares based on the size of your contribution. But equity cannot change law. So equity can only change the beneficial interest. Okay? So does this help? It looks like it does in the chat. So is it helping you guys here in the room? So, okay. So this is the way it works everywhere. In Belize, the legal interest cannot be a tenancy in common. Everywhere else in the Caribbean, it can be, and that introduces fractionation that we talked about on Tuesday. Remember, I talked about the native lands in the US where people owned 1,000th of 1% of a piece of property, right? So in Belize, that's not a problem. Everywhere else in the Caribbean, it can be. In Antigua and Dominica, okay, remember I said in the Caribbean, we presume a joint tenancy unless there are words of separation. In Antigua and Dominica, we follow the American rule of presuming a tenancy in common unless there are words of survivorship. Okay, so to give you a quick checklist of the jurisdictions, okay. You can have a joint tenancy at law and at equity, and it's presumed. You can only have a tenancy in common at equity. In Antigua and Dominica, you can have the joint tenancy at law and equity and the tenancy in common at law and equity, and it's presumed. And everywhere else, you can have the joint tenancy in law and equity and the tenancy in common in law and equity, and the joint tenancy is presumed. Okay? Does this help? Okay, does this help you guys? Let me Vanna White it for you. Okay. So does this help you guys understand sort of how the scope of this plays out?
Yes, it is.
And you're going to take a picture. Okay. So do we understand why the unequal purchase money presumes an equitable tenancy in common? So, okay. So to answer the chat in order, right? The presumed part means that where you don't see presumed, we have to have specific language to create it. So for tenancy in common, right? So that's Belize and everywhere else. We have to have language of taking share and share alike, or taking in common, or taking in shares, right? The text sort of gives you the list of the magic words. And if those magic words aren't there, it's a joint tenancy. In Antigua and Dominica, the magic words are take as joint tenants, take jointly, take with right of survivorship. And if those are not present, then it's a tenancy in common. Okay? Megan, so the issue with the unequal purchase money is even if you have a joint tenancy, okay, so for example, if you're in Barbados or the Bahamas or St. Kitts, where we have a presumed joint tenancy, okay, if the buyers contribute unequal purchase money, there will be an equitable tenancy in common. Okay, so there will be a legal joint tenancy and an equitable tenancy in common. So does that help? Does that answer your question? Go ahead. I am going to say that my impression from my reading is that these presumptions all refer to the legal estate. So these are all situations where the presumption goes to what the legal estate is, and then the equitable estate is only presumed in these cases that we're about to go through. Okay. Okay, not quite, Megan. So Megan says in chat that with unequal purchase money, in Belize you have a joint tenancy, and in other countries you have a tenancy in common. With unequal purchase money, right? So this is specifically referring to when equity presumes the tenancy in common. This list, okay? So in Belize, equity presumes a tenancy in common is this list that I'm making over here on the right. Okay, so in Belize, you can only have a tenancy in common in equity. So if there's a statement that a tenancy in common is created, right? If the conveyance says to A and B in shares, then in Belize, they hold the legal estate as a joint tenancy and only have an equitable tenancy in common. Okay.
Sir, can you say that again slower? I don't know why it's not. Sure.
So this whole list has to do with equity, and there's going to be more on the list in a minute once we sort of understand what's already here. The first thing is that in Belize, okay, if you try and create a tenancy in common through a conveyance as the legal estate, you fail at that because that is not a legal estate that is permitted in Belize. What you create is a legal joint tenancy and an equitable tenancy in common. Right. So does that help now?
Okay, so when the HTT arises, in Belize, there's no joint tenancy? No. So let me give you an example, okay? So a conveyance that creates a tenancy in common is to A and B in shares. And that language in shares is what signals the tenancy in common, okay? If you do this in Belize, what you create is a legal joint tenancy that's held by A and B in equal undivided shares. But because
you're trying to create a tenancy in common, and we will give effect to that to the extent that it's allowed. So we create an equitable tenancy in common held by A and B in shares. Okay, so does that help now? Great, okay. Now, on to the unequal purchase money. What?
Can you give, I think we've got it, but maybe an example of split, right? Because I think what I understand from this is that in the lease you get the legal joint tenancy, but if you want to create or get any tenancy in common, it has to come under equity.
Yeah, so it's not a has to come under equity. It's that law does not allow what you're trying to do when you try to create the tenancy in common. But we want to give effect to your intent as the grantor. And so we allow it in equity, but the legal estate will be a joint tenancy.
Oh, sir, why you would just say that? That's crazy. So basically, equity is just, you're not trying to be equitable, for lack of a better word, because there is no such thing as a tenancy in common. A legal tenancy in common. Because sir, that's it. That's all you had to say. No. Okay.
Well, sometimes it's that we have to sort of go through some iterations before we find the one that clicks. So it happens. And the question from Nicole, is that the joint tenancy is presumed in Belize. She was just complaining that suddenly everything was clear. And why didn't I just say that to begin with? Megan, let's come back to your question now. Talk about unequal purchase money. Okay. So unequal purchase money is another one of these situations where we're trying to give effect to the intent of the participants. And the conveyance may not successfully create a tenancy in common. Okay? Because remember how I said 2A and B in shares creates a tenancy in common. If you don't have that magic language, whatever it is, and there's several different types of it, but if you don't have it, then we presume the joint tenancy everywhere except Antigua and Dominica. But we presume the joint tenancy in most places. So we do the conveyance, we create the joint tenancy, but we go, wait a second, what you brought to the table isn't all the same. Okay? And so equity says, yeah, sure, law says there's a joint tenancy, but that joint tenancy is for the benefit of a tenancy in common that's divided according to your contribution. Okay? So Megan, does that make sense now? Great. All right. The next category where equity presumes a tenancy in common. And again, all of these are situations where we don't care what the legal estate is, okay? The legal estate can say anything, can create anything. We're not concerned about it. We're saying these are facts that will create a tenancy in common in equity, regardless of what law does, okay? So the third one is the loan on a mortgage. Okay, so a mortgage is a legal estate. And so it has to be handled by deed, and the conveyance may not successfully create a tenancy in common. But truth be told, this is essentially the same thing as the unequal purchase money. Okay, you have multiple lenders contributing to a mortgage, and they hold it jointly, but they each only hold what for the value of what they contributed. Okay, same thing, it's just that instead of a purchaser, we're dealing with the creditor. Okay, so these two are functionally the same thing. If you understand this one, you probably understand this one, and also the flip is, the reverse is probably true. Okay. The last two situations where equity presumes a tenancy in common are both about business. And that's where partnerships, right, where partners buy property together. And lastly, where non-partners buy property together. So these are fairly straightforward, right? There's no reason for, if A and B are business partners, there's no reason for B's heirs to be cut out of partnership assets. And so property that is purchased by people who are in business together is held equitably as a tenancy in common, even if they hold it as a joint tenancy at law. Because the fair outcome is for the dead partner's heirs to be able to take their ancestors' share of the business's assets. Okay? And then the separate businesses is just like, if you and your neighbor buy a building and you open a Chinese restaurant and your neighbor opens a tailor shop, right? Even if you hold the property jointly, because you're conducting separate businesses on it, we're going to create an equitable tenancy in common. And that's going to be divided according to the share of the property that you're making use of. Okay. So, Justin, the answer to that, Justin asks, do we all have to do over the estates assignment and submit? The answer to that is everybody has to resubmit the estates assignment. If you're happy with your grade, just resubmit the same thing, make a note on it that you didn't make any changes, and I'll just go in and reassign the same score. Okay? Oh, that was a question that I got in email, and I was going to send an announcement. It's out of 100 marks. So if that changes your assessment of how you feel like you did. Okay. Sorry, does the mortgage apply to husband and wife? I think there's two questions, Nicole, I think there's two questions contained in that. The first is, if the husband and wife are the creditors, then probably. If the husband and wife are the debtors, I think that's a question for the family law course. And then for separation, do you mean the value? I'm not sure what you're asking there, Keandra, but separate businesses just means that you're not engaged in the same business enterprise. So you're not running one business out of the piece of property, you're running more than one. So. Okay, I don't know if that answers your question. You may have been asking about something else, but that's what I think is what you're asking. Okay, so we are out of time, and my laptop is giving me the hairy eyeball for battery life, but I'll see you guys on Thursday. I have written the video for this week's tutorials. I have not had a chance to record it. If I don't get home before sundown tonight, I will record it in the morning because the light in my office is garbage. So it may be tomorrow before I get it up, but I will get it up today or tomorrow, depending on when I get home tonight. Okay, so thanks so much, and I will see you guys on Thursday.